May I please Rosif, I beg to mention item number 10. Conducting counsel is under treatment as he did surgery on his dental mobility. And the matter may be taken up to 3 weeks.
Number 10.
10.
What is required here?
It's for final hearing, ma'am.
Hearing not,
My
not
lord.
commenced.
My lord.
Hearing has not commenced.
No, not yet.
Any objection?
No, absolutely not. Mr. Mansoor is under treatment, my lord. He's undergoing surgery.
Mr. Naira Counsel has sought for accommodation on behalf of the respondent on the ground that the learned conducting counsel is indisposed on grounds of personal difficulty. On premier, the same is allowed. This is matter up to 3 weeks.
Supplementary list, item number 1.
May I please, Your Lordship? My Lord, there are 2 bail applications for the same accused person. So item number 2 may be taken first because there is section 27 is invoked where section 37 will apply. In this case, my lord, this petitioner, she was arrested on 25/9/2024. It was alleged that source information was received that she was doing some trafficking in this contraband, and accordingly, based on the source information, it is alleged that based on the source information, the police they searched the house of this accused person. And during the search, it is alleged that small quantity of contraband of heroin, 3.57 gram, was recovered, a small quantity. Later on, my lord, it was alleged that some lady from the neighboring nearby, she has informed to the police that there is also another contraband lying near her shop. So that one was also seized, which was also intermediate quantity, 6-point-something gram. And it is alleged that as per the seizure list, it is alleged that all the recovery was made from the house of the accused. Whereas the FIR and materials on record, it suggests that a small quantity of contraband was recovered from her possession, from her house, not from her possession, from her house, and another from nearby shop. So there is contradiction with regard to seizure list and the material on record and the FIR. So my lord, in this case, charge sheet was filed, and as of now, 2 witnesses has been examined. My lord, on the last occasion, I was to furnish this. I have already furnished a copy. The statement of these 2 witnesses.
How many witnesses are there?
My lord,
How many witnesses altogether?
there are total about 11 witnesses. Out of 11, 2 has been examined. So. The 2 witnesses has been examined. 1 officer who received the source information, 1 and 2. So my lord, he has already stated in the examination in chief that he has done, information was received, all this what in the FIR is there, he has stated.
Seizure?
Yes.
Yes.
I'll just point out, my lord, the cross examination, it will be easy. In page number 6, my lord. The cross examination. Point number 7, my lord.
Yes.
I agree to the suggestion that the source of information received was not reduced into writing. So this is violation of section 42. So during the course of the trial, it has come. And my lord, number 13, it says that it is also correct to say that in exhibit 2, which is noticed under section 50 of the NDPS Act, that the accused was explained in the language understandable by her was not mentioned. So they conducted the search also. So they served the section 50 notice prior to conducting the search, but the notice is not nowhere mentioned that it was explained to the language which she understood. So this is another violation, my lord. And 18, my lord, cross examination 18. It is a fact that we have not offered ourselves for search before entering the house of the accused person, but it was conducted through videography. So they have not offered. So many persons they entered in the house, but nobody offered themselves to be searched prior to the conduct of the search. And 22, it is also correct to say that
offered to be searched has to be before magistrate or gazetted officer.
my lord, before searching a house, so to avoid any doubt that the substance was planted by any of them, so they used to follow the procedure that prior to conducting the search, at least they should offer themselves for search. Body search, section 50 applies, but search of the premises, if they enter the house, then they have to offer themselves that to avoid doubt regarding plantation. So that has not been done. And 22, it is also correct to say that a sketch map of the location where the alleged drug was recovered was not prepared on the day of incident. Now, small quantity of contraband was recovered from her possession, and they have said that they have also recovered certain contraband from nearby shop outside of the house of this petitioner. So, but they have not prepared sketch map on that day itself. So the sketch map which was prepared, it was prepared later on. So the sanctity of this sketch map is also doubtful. Now 27, my lord, it is a fact that material exhibit 2 and material exhibit 3, which are the 33 and 40 numbers of vials produced before this court today, are all empty. 33 numbers of this container was recovered, it is alleged that recovered from the house, and 40 was recovered from some other place. So all those which they have produced in the court are all empty. Empty. Maybe they have like they might have emptied
it into some
yes, some, but there has to be some material that they have taken out this all and put it in one
one
container or they have packed in one, but there is no material to that. There has to be some material to connect that it was emptied and thereafter it was cumulative measured or weight. That is not there. That how they have done this one. And my lord, 29, it is also correct to say that no drug was recovered from the physical possession of the accused. So that is admitted only because there is no case that it was recovered from the possession of the accused. It was alleged that it was from the house. So the next witness, my lord, is number 2. So he is also an inspector who was present, it is alleged. In his cross examination, my lord, I'll just take, that is page number 3 and page number subsequent page number 4, my lord. So in this cross examination, he has stated that it is correct to say that information was received on 25/9/2024, and on which day also, my lord, search was conducted and the accused was also arrested. But my lord, FIR was lodged on 26/9/2024. That means after everything was done, formalities, they have lodged the FIR. So this is violation of section 173 of the BNS Act, which says that if information is received, they have to immediately record in their book, and the information, the contents of that information, they have to reduce into writing, and thereafter a case has to be registered, and thereafter investigation has to be done. But in this case, they have done all the formalities and thereafter they lodged the FIR. Everything was done thereafter. And my lord, I have pointed out already that the source information was also not reduced into writing. One witness has said. So it is also correct that number 3, that FIR was lodged after all necessary formalities were carried out. And number 7, my lord, I cannot say how much is the total weight of 33 vials containing yellowish orange powder which were seized from the house of the accused. So this police inspector, he was very much present, but he has also not able to disclose how much was the contraband recovered from the house. Number 10, my lord, I do not know what was the total quantity of contraband alleged to have seized from the accused. At that point, number 12, my lord, at the time of conducting the body search of the accused under section 50 of the NDPS Act, I do not know in what language the accused was communicated or explained. He has claimed that, my lord, that he was present on the spot and in the search procedure he was present, but he cannot say all the things. And number 15, my lord, paper book mark 1 is a ready-made format filled up by. So there is a authorization and all these things. Their ready-made format is there. I'm not going on to all these details. Only the sanctity of the seizure is doubtful as of now. And, my lord, although it is claimed that intermediate quantity of contraband was recovered, it is evident that small quantity of contraband recovered from the house. And there is also doubtful that how they have done and how they have mixed together all the contraband and they have weighted. There is no such material. And, my lord, section 27, intermediate quantity was recovered and section 27A has been added. Section 27A has been added because once the section 27A will be added, the bar under section 37 of the NDPX would apply. So, my lord, I will take, my lord, the FIR. FIR, my lord, from the beginning only there was no allegation. FIR is at page number 11, my lord. So, in the FIR, all the details has been written, how they have got the information and all these things. My lord, last paragraph, I'll just take, my lord. Accordingly, Miss Nina Rava, MPS Deputy Superintendent ACP, CID was informed, and when she arrived at the spot, notice under section 50 NDPS Act was served to her in presence of Miss Nina Rava, WPSI PCH Momin and independent witnesses. Thereafter, Miss Nina Rava authorized WPSI PCH Momin to conduct body search of Srimati such and such, maintaining strict regard to decency. However, no illegal contraband was found from her possession except cash amount to rupees 27,410 rupees, a voter ID card, and one Realme mobile phone, which was recovered from a black color sling bag that she was carrying. Accordingly, preliminary test was conducted in presence of the independent witnesses, and the substance indicated positive for heroin. Thereafter, suspect yellow-orange powder were weighed separately on small scale digital weighing machine in presence of independent witnesses, and it was found that the total net weight of the suspect heroin is 3.67 grams. Now, while observing necessary formalities, one lady named Srimati Noor Jahan Begum, who runs a pawn shop located next to the house of Srimati such and such, inquired from WPC such and such about the ongoing matter, and she informed that suspected heroin was recovered from the house of Aisha Khatun alias Pahari. Then Srimati Noor Jahan Begum informed such and such that Srimati Aisha Khatun alias Pahari kept one container near her shop in the morning and told her that she will take it in the evening. Accordingly, the container was taken from the said place in presence of independent witnesses, and upon opening, one parcel plastic found, and inside 40 numbers of vials containing yellow-orange powder suspected to be heroin was recovered. Similarly, preliminary test was conducted in presence of independent witnesses, and the substance indicated positive for heroin. Further, the suspect yellow-orange powder were weighed separately on a small scale digital weighing machine in presence of independent witnesses, and it was found that the total net weight of the suspect heroin is 6.5 grams. Then I seized the suspect heroin, which altogether weigh a total net weight of 9.72 grams, along with the Nelex lock and keys, the black color plastic and the transparent plastic, the white container, and all these things, mobile and all, my lord. This is the allegation. So, from the beginning, my lord, there is no allegation in the FIR. This FIR was also registered after one day, 26. It is not the case that it was registered instantly and the entire contents was recorded instantly.
She was apprehended on 25.
Yes, my lord.
With what time?
She was apprehended around 1 afternoon.
No.
Yes, my lord. It is
FIR
also mentioned here, my lord.
FIR was dated 26,
FIR is 26.
1 a.m.
This is FIR was registered 26, my lord.
1 a.m.
Date time is not mentioned, my lord.
So I think the Pirulu one must have said that.
Oh, okay.
Anyway,
And
but if that is the case, because you're
yes,
talking
yes.
about hours,
Yes, yes.
just matter of,
All right. So
see, if you talk about dates,
yes, yes. The hours duration I have not said.
25 and 26 are
Yes,
24 hours.
yes,
But 25 night or evening and 26 morning,
yes.
early morning or midnight makes a difference.
All right.
Anyway,
That is even
That's
2-3 hours also duration they have to explain at least. In 2 hours also anything can be done. That contents can be changed. So, my lord, this is the FIR. I am not on that. I am on that, your lordship, that there is no allegation in the FIR that she has harbored any person or she has facilitated anyone in doing all these things. She has not financed. There is no allegation that she has financed anyone. If this finance and harboring comes, then another accused has to be there. So there is no allegation. So the FIR without any ingredients, the FIR is registered under section 21B and 27A. From the very beginning, 27A has been added, despite there being no material. So the intention of section 27A, invoking section 27A, is only to stop her from procuring bail, to get bail. Because once section 27 will apply, I have to satisfy the twin condition.
yes.
So that is, but my lord, there is no such ingredients. I have read this statement of these two witnesses also. As of now, there is nothing that she has financed or she has harbored any witnesses. So in this case, my lord, section 27A is not applied. Therefore, section 37 bar would not apply. So I have to satisfy, my lord, that whether now, my lord, since the accused is in custody since 25/9/2024, almost 10 months, more than 10 months, and 2 witnesses has been examined so far. So, my lord, and admittedly, allegedly, it is a small quantity of contraband was recovered from her possession. So, my lord, if bail will be granted, there is no harm, my lord, that she should be stopped and she should be detained till conclusion of trial. So, my lord, she will comply with the condition and she will appear, she will contest the case. And one more thing, my lord, that I wanted to point out, that preventive detention for this accused person on registration of this FIR, another case was previously there. So they have an order was passed for detaining her for 3 months under preventive detention. 3 months already over, and there was no continuation of this detention order. And the detention order was passed considering that there was 3 cases, 3 pending cases. But my lord, one case was there in 2015 in which she was acquitted. She has already been acquitted, but that I am not going into that. That was not considered by the while passing the order. So this order was passed, taken into consideration of that case also, which was already over.
As far as that detention
is concerned, I am not, because that is not.
that is over.
Yes, just to point out, my lord, that one. I am not suppressing anything. That's why I have highlighted. So in this background, my lord, bail may be kindly granted to this.
Ashok, on the last date, when he was referring to the High Court's order.
Not in this case, in that other case.
Okay, but it has bearing both the case of a. So, Lordship, the order of the High Court is at 28/3/2025. If the copy is given to the court.
If that bail was cancelled, then I.
No, it's okay. So, Lordship, the date is very important. 28/3/2025. No, why the date is important, Your Lordship? Because the argument was forwarded as if like from 25/6/2024 she is there, 2 witnesses. So, no, we'll come into it. Let me submit. Maintain something here.
What is the relevant date here when the FIR was filed?
Lordship, relevancy is this. I'm only basically into section 54. Other evidence part of it, Your Lordship, because he started with cause. I'll come later into it, but Lordship will just kindly come to section 54 of the NDPS Act. Prevention of illegal traffic, and the stringent provision was invoked. There are 2 cases pending. Bail was granted, bail was cancelled, and now we have to address the issue of section 54 in both the cases.
Yes. Yes.
Presumption from possession of illicit article. In trials under this act, it may be
You're talking
54 NDPS Act.
54.
Your Lordship.
I thought 24.
Sorry.
Yes.
Lordship, presumptions from possessions of illegal articles. The starting word is very important, Lordship. In trials. So the issue is trial right now.
Yes.
In trials under this act, it may be presumed unless and until the contrary is proved that the accused has committed the offence under this act in respect of any narcotic drugs. Details, Lordship. I'm not going to the details because the first part is very important. During trial under 54, it will be presumed until the contrary is proved that the accused has committed an offence under this act. Now, it's an admitted position, Your Lordship. The argument forwarded is small quantity, intermediate quantity. Then he relied on both the depositions and he started off with cross. In the in chief, what was stated in the FIR, we find that in the in chief. And further, that part of that 40 viral being tested and found to be heroin, it's an admitted fact in both the deposition. Number 1. Number 2, the admitted position is from the house. He also has read out that. The only thing that he was trying to shake was, it was not from a possession. 50 will not be applicable. Admittedly, yes, it will not be applicable. And then the issue of empty container and witnesses not saying what to that. Those are, Lordship, minor contradiction. Of course, I'm not doing a hearing on merit, but prima facie, Lordship, those are minor contradiction. But the substance seized from the house is corroborated, has not been shaken, and admittedly is found to be proved. So if that is the evidence that is before the court, I'm not on to other part of it, Lordship. There are multiple cases. One of the most important twin requirement of 37 is this: when you are released on bail, you are not supposed to commit similar offence. The relevance of 28/3/2025 order was that she was granted bail and then it was cancelled. Against cancellation, she approached this court. This court, Your Lordship, if I may just take Your Lordship to 28/3/2025, page 3. Lordship, you've got the copy of the order.
Yes.
Second paragraph. Mr. So-and-so, on the other hand, vehemently opposed the submission made on behalf of petitioner and submits that the fact of petitioner's arrest in connection with so-and-so clearly shows that petitioner has violated the condition of the bail stipulated in order dated 1/8/2023. He submits the petitioner is a habitual offender and has misused the liberty granted to her by indulging in similar offence again. He submits, so Lordship, I'll not bother to read detail. The Lordship will come to the next page. He relied on a judgment. The finding of the Honorable High Court, Lordship. From the submissions made by the parties and documents and record, is apparent the petitioner, subsequent to a release on bail by order dated 1/8/2003, was arrested again in connection with Lumdinjiri PS case involving under NDPS. There is a clear stipulation in the order of 1/8/2023 at condition number 1, the petitioner shall not commit any similar offence. The learned session judge, while dealing with the application for cancellation way, more particularly as to the question of locus standi, the applicant found that the applicant was a complainant of Molai case number so and so and accordingly rejected the objection. Nothing has been placed before this court by the petitioner to attribute any illegality above finding. As to the merit of the case, this is important, Lordship. The learned session judge recorded that the petitioner admitted that she was arrested in so and so, which has been charge sheeted and pending trial before the court. Further, the provisions of sections 35 and 34 was taken into consideration to justify the view that the presumption exists that the petitioner has committed the offence under so and so and so and so. This court also does not see any reason to interfere with the aforesaid view taken by learned so and so. Now, of course, Lordship, I'll just come to the part taken from the bottom, Lordship. 1, 2, 3, 4, 5, 6, 7. From the bottom, the ninth line, Session Judge has taken into consideration the fact of filing of the charge sheet in so and pendency of the trial against petitioner before recording its satisfaction as to presumption of commission of similar offence by petitioner. There is no denial of the fact that both
page 4.
Lordship, sorry, page 4, last part, Lordship. Page 5, Lordship, sorry. The first paragraph, but from the bottom, the 7th line. 8th line, sorry, sir. If you just read the operative part, Lordship, there is no denial. There is no denial of the fact that both the cases, now we have got 2 cases, Lordship. Molai case and Lumley's cases are pending before the learned session judge, Shillong. Thus, the contention raised by the learned counsel for the petitioner is not supported by materials on record. No, we are not into the other merit part of it, Lordship. There are 2 cases already pending. Detention order had to be invoked. That has elapsed. My purpose of saying detention order, 2 cases pending, bail granted, cancelled, approaching High Court, a High Court finding no prima facie material. Now, if my learned friend is trying to argue that since 25/9/2024, only 2 witnesses have been examined and there's a case of delay, Lordship, I don't think so there's any precedent. We've got so many detention order passed, 2 criminal case pending. If there is a very unique case on that count and then delay is considered, yes. Otherwise, none of the ground for delay will be applicable here because of the nature of involvement of the accused. Number 1. Number 2, 54 clearly says during trial, if the contrary is proved. Now, admittedly, even if you see it for the sake of argument, Lordship, both the case of proving from a house is established in both the deposition. The contrary proof will come only, Lordship, again coming back to CRPC and 315 and 313 where she denies it. That stage is not here. For the purpose of prima facie, for the purpose of 27A, 54 and 37, the 37 twin condition clearly says, even if you release on bail, you're not supposed to commit that. Now, we have a High Court order where they have approached after commission of offence and that was rejected. So the prosecution is further strengthened and we can buttress our argument further. The presumption on the 54 is further reinforced in light of these facts. So the issue of 2 witnesses being examined and another witness is yet to be examined are of no consequences so far the involvement is concerned. Even if the court wants to consider 37, prima facie, Lordship, she is committed an offence, second offence. So, 2 witnesses and delay, and a ground invoking this court that there has been a delay, she should be released. I'm sorry, Lordship, this is not a call. And she's an habitual offender, the court has observed. An habitual offender who gets bail, comes and commits crimes and again gets bail. And my learned friend made me mention that acquittal. It could be a technical acquittal, it could be for the fact remains that there was a trial regarding. So there's a third case involved. Acquittal plus both these cases, prima facie, Lordship, establishes that presumption has not been discharged. That stage for discharging of presumption, if contrary is proved, has not reached. What is the stage of the trial is? 2 witnesses and further witnesses. There is nothing to show that they have discharged the burden. In that view of the matter, Lordship, both the bill application, considering the other aspect of the matter, I think so it's too premature. And on the issue of prima facie, there's absolutely prima facie that she is involved in this case, and Lord should take a very, very stringent approach, especially dealing with menace of drugs like this, Lordship. My submission would be, Lordship, this is absolutely not a case for grant of bail in light of all the submission. And the last part, Your Lordship, would be, at this stage, court may not go into in chief and cross-examination and appreciate the evidence. Even if he wants to shake it, that part is not there. But even if you rely only on the in chief and cross, a prima facie that it was seized from a place is clearly in the evidence. So, Lordship, both the bail application should be rejected.
This application
My lord,
is in connection with what case?
this is in connection with criminal NDPS 1 arising out of Lumdingiri PS case number 103
Lumdingiri.
in bracket 9 of
The
2024.
reference in this order 28.3 is
Regarding that
Mawla
another
IPS case.
Yes, my lord. My lord, this bail in Mawla PS case, which was in 2023, that after registering of this case, that bail was cancelled. I did not go for bail before. I did not approach for bail before the High Court. I challenged the cancellation order. I challenged the cancellation order on the ground that mere registration of case is not cannot be a ground for cancelling the bail. Bail has to be cancelled on certain strict violation. So that was totally different, my lord. In this is not in connection with this case. My point of argument was different in that case. That is not connected in anywhere with this case, this order.
No, but it involves you.
No, that is, I am admitting,
You
my
are-
lord, that
you are the main accused in all these cases.
yes, I am that one. I am not disputing, my lord. My contention before that, I approached before the High Court challenging the cancellation order, which the learned NDPS special judge cancelled my bail. On that point, I just approached the Honorable High Court. This is nowhere connected with this case. There is also no dispute that I have no case. I have two cases. One case, another case was there, it was acquittal. That is I am not disputing. So in this case, I have argued on merit, my lord. The purpose of classification of the offences under NDPS Act was is already there. If that in every cases, if bail will not be considered, then the whole purpose of section 37 would frustrate. There is no there is no occasion for section 37, my lord. That why section 37 has been there in the statute. Because
Just a moment. Mr. Khan, sorry to interrupt.
Absolutely.
You have not made any points of argument. You have not raised any points of argument as far as Section 27A is concerned.
Lordship, section 27A.
What does
If you read again the
the
FIR.
materials on record says
No,
as
Lordship,
far as
if you read the FIR, let us read 27A. First, let us read, Lordship. (27A) says, Lordship, punishment for financing illegal illicit traffic and harboring offenders. Whoever indulges in financing directly or indirectly.
see, because Section 27A
Lordship.
has a nexus with Section 37.
Lordship, yes.
It was on that, you see, on that basis that she was admittedly the seized contraband substance was of a small quantity.
Lordship, correct.
Small quantity.
yes, from the position from the house of the accused.
Okay, from the house of the accused.
Yes.
Okay. Forget about the fact that we will not go into the issue of constructive possession, this and that.
Yes, Lordship, absolutely.
The fact remains, it was seized from her house.
Yes.
But then, why she was not granted bail is because of the embargo of
37.
37. And that is because of the
Section 27.
Section
Yes,
27.
correct.
So now we have to prove.
Lordship, I'm grateful Lordship will pose this question. Lordship, there are two situations. Had it been the case we are arguing before charge, if this was for consideration of charge, it's a very, very valid question, Your Lordship. They have missed the bus. Two witnesses have been examined.
Okay.
Number one, Your Lordship. Number one. And now we have evidence of two witnesses. So whether this charge should have been framed or not, they had an opportunity at the time of framing of the charges. Two witnesses have been examined,
Just show me the charge.
we'll have to go to the charge. Next, the copy of the
Charge, my lord, charge is framed under Section 27A also.
Where is it?
It is not here, my lord. I have pleaded in my petition.
But from the charge, we'll know.
Yes.
See, when the charge was framed,
Absolutely. And
what was the the rendition of the
Yes.
trial court?
Yes.
That because of so and so evidence against you,
Yes. Yes.
you have been
Yes.
violent, known, or you have finance, whatever,
Yes.
whatever language is used.
Yeah, absolutely.
That fact has to be has to be noted by the trial court
Yes.
when the charges was framed. So I just want to know firstly the language
Of the charge.
of the
Yes.
charge, and secondly, see whether. But again, as Mr. Khan has said, I don't think at this point of time we can come and say that
He
there
can't
are
say
no evidence.
No, that is
as regard that.
Yes.
my lord.
aspect.
Only this honorable court. I am for bail now. This honorable court cannot just ignore only on technical that since you have not raised that point, I am on bail. That one it will be trial.
Mr. Pandit, the fact remains this: when as far as section 27A is concerned,
Yes, my lord.
charges have been framed.
Yes, my lord. That is framed.
You see, now
Yes.
if it is framed,
Yes.
it means prima facie, the court is satisfied, convinced on the basis
Material.
of the investigation
Yes.
that you have committed an
Yes.
offence,
Yes.
relatable to 27.
Section 27.
And
yes.
lordship is a settled position. Like while framing charge, the court is not supposed to give a reason.
Of course.
Prima facie, yes. No, I'm just.
there has to be material.
No. While framing charge is a frame in one head. Court will. That is why lordship before framing your charges, this argument are held. If you are aggrieved, no, he can always come to the High Court saying the charge was framed. Now, if he has missed the bust and he's waived it right at that stage, he's saying right now that 37 embargo will not be applicable because 27A ingredients are not there. This argument, Your Lordship, cannot be argued in a bail matter when the charge has been framed and he's coming to that. He can raise this issue only when 314 is over, and then he gets an opportunity in a 315. That I never was there on oath. If he has missed the bus. And so even if he gets a copy of the charge sheet, there will not be specific discussion on that.
Yes,
This
there
is a
will
settled
not
law. And nobody can challenge a charge frame on the ground that it was not a speaking order. Then court will have to again go back to the charge sheet
Yes.
and appreciate the evidence.
Exactly, that's what-
That, Lordship, that can happen only when he challenges the framing of the charge itself.
Definitely.
Now, we are not in 227 of the CRPC.
Otherwise, you see, Mr. Pandit, irrespective of whatever has been submitted, whatever is there on the court, the fact remains that because of the presence of section 27A, so section 37 will come into play.
Absolutely.
And on that, you have to satisfy this court that
My lord.
you are not involved, you are innocent.
All right, my lord. I have already stated in my argument, my lord, that there is no bar, my lord, that in the bail stage, I can point out before this honorable court, I can point out the material. There is no bar, my lord, that section 27, if at all, was at that point of time was invoked, charges was framed. I cannot argue on that also before this honorable court. There is no bar. So the court has to see, my lord. The court has, the honorable court has to see.
You have to lead the court through the materials on the court.
Yes.
As to
Lordship,
what was the finding as far as 27A is concerned?
Lordship, if he wants to forward this argument, I'm glad that he's forwarding this argument. Then he has to assess the court when saying from 1 to 12 witnesses, who are the witnesses? Then a very different argument then we have to forward. We have to see every witness, then we have to identify who are the witnesses who are Caesar witnesses, who are 50 witnesses, who are the witnesses who comes within the meaning of 27A.
Yes. Who
That
has
one also I can point out.
And Lordship, that would again be, if we embark on that journey, we are again going back to argument before charge. Lordship, kindly appreciate, it's a very, very thin line here. That argument we can do only when argument before charge. Even we embark on getting all the list and then trying to say, how does 27 comes in, which witness comes in. Supposing we find out, Lordship, witness number 6 does it. He has not come to the box.
No, the point is this, Mr. Pandit, if I understand correctly. Charges have been framed under 27A.
Yes.
As Mr. Khan said, it's correct. See, this court cannot go and revisit
Absolutely.
that. That part of the investigation to say that maybe you may be right, you may be wrong, we don't know.
Absolutely wrong. I may be wrong. Also. I may be wrong. Yes.
The court was wrong in framing charges under 27A.
Absolutely correct.
If that goes,
Everything goes.
Then your other, contention will remain.
Correct.
But as long as it is there, then still the court will have to refer to section 37 when your application for bail, as is done here, as you consider.
Because right now, Lordship, for a moment,
Understand the situation.
Lordship, for a moment, the situation is supposing he gets the charge sheet and we embark in finding 27 was done on that. In the garb of a bail application, we'll be arguing again, revisiting argument before charge.
Exactly.
Which is not the case. There is no petition involved.
At this stage, the court
No,
can't say right or
absolutely.
wrong.
Lordship, that's why I'm submitting, Lordship. If that is the situation, the rigor of 54 will come. Presumption.
Presumption, of course.
Presumption and presumption position. We have to make a distinction.
Not harboring.
We have to make a distinction between indirectly, found in the house, read out in the FIR. The other lady said there was a container. Admittedly, there's a loud whisper on the container. So now these are ingredients that has to be tested when the witnesses come to the witness box.
That is the other aspect of the matter.
Lordship, yes. So at this stage, Your Lordship, in the garb of whether 27A was involved or not, we can't in a bail application argue that to find out whether embargo of 37 is applicable or not. Court has to limit itself only to the presumption of section 50.
The only thing that you can press, Mr. Pandit, is this. You have to take it. You see that section 27A is present.
Yes.
And from there you convince the court that in spite of the presence of 27A, you are still entitled to bail.
Absolutely correct.
On other consideration.
We are grateful, Lordship. Lordship has formulated the questions well. Yes.
So, yes, my lord.
Yes.
I have to satisfy this honorable court that section 27, even if it is invoked, but still I
is
am
entitled.
Yes.
Exactly.
There is a reasonable ground to believe that I am not involved. In section 27A. In section 27A, I have to satisfy the honorable court that I am not involved. There is reasonable ground that I have not committed the offence. Which offence? Section 27A.
But that has become a subject of trial.
That is okay.
Yes.
That is okay. But at this stage, even if suppose section 37 is applied for section 27A, so I have to satisfy this honorable court that there is reasonable ground to believe that I have not committed offence under section 27A for that particular offence. So I have pointed out, my lord, that the material on record, even if I will read the statement of entire witnesses,
You have said that.
yes.
Nothing,
So there is reasonable
according
ground.
to you,
Yes.
nothing is there in evidence
Yes.
that section 27A can be attributed to you.
Yes. And there is reasonable
The only
ground.
thing is that there are two portion of
Yes.
the substance was found
Yes.
in your house, in the shop.
Yes.
That's all.
Yes.
So, but the fact remains that when the IO has filed his charge sheet, incorporated 27A, as Mr. Khan has rightly said, before consideration of charge, you should have argued that point.
Yes.
That one.
I know whether it was done or not, we don't know.
It was.
And then, if it was done, then
Then,
what
yes.
is the
Section
decision of
27 could have been dropped.
no, what
That
is the
right.
yes? What is the decision of the trial court? It could have been dropped. It could have been sustained.
Then
we
we
don't
could
know.
have challenged.
That is now that that being the case,
Yes.
your application here, still has that. That tag of 27A is still there.
Absolutely. Tag is there, and admittedly, Your Lordship, the in-chief says 40 vials was recovered from the house, not from the body. And
Will not.
no, Lordship.
This court will not go into the
Absolutely.
the evidence of because there are another 10 witnesses also.
Yes.
They may
yes.
come and say otherwise.
Otherwise, yes.
They may disprove you or they may prove.
At the moment, Your Lordship, the burden of 54 presumption, the prosecution, by leading two witnesses that he relied, has discharged the burden. Contrary to be proved, that is yet to come.
Okay, Mr. Pandit, we'll cut it short. You have any authority on this as far as the
27.
the element of 27A being present here, which would entitle you to still, a bail.
Yes. Let him come.
My lord, I'll just
Please just
come
check
to
on that.
Yes.
Because it's difficult. Perhaps if that section is not there, 37 is not there, you may be.
There
you
are
may be entitled to bail,
certain judgment, my lord, where it says that even though section 27 is invoked, but this honorable court has
Exactly.
jurisdiction
You have that.
section,
come with the
if the
We'll still oppose
this
it.
moment I don't have, my lord.
Because the prosecution
No,
stand will
only
always
even if suppose, my lord, even if section 37 applies, 27 is there, section 37 applies, then also I have made out a case that there are reasonable ground. Section 37, the ingredients of section 37, I can satisfy, my lord.
repeated offender.
No.
How can you satisfy?
In this particular case, there is nothing in this NDPS Act that if there is
37 has it, Raj.
no for offence under section 37A
See, Mr. Pandit, we go back to the
again.
basics. Bail is considered looking to the severity, nature, gravity of the offence, antecedent of the accused. Your antecedent will prove that
My antecedent is not
you are involved in too many
Habitual offender.
three cases. Three cases.
Cancellation of bail, all those things will come to question.
Yes.
So you will have to overcome that also.
Yes.
So you cannot say that
Once suppose I am involved, it is not that, my lord, I will not get bail
See,
for
you
the
may-
entire.
It's not that you will not be, but your antecedent has to be
Yes,
tested.
antecedent is not that
So
good.
see, and then section 37, as Mr. Khan has rightly pointed out, the stipulation is there. You may be granted bail, provided you do not commit similar offence. But this court again has, in that order of 28.3, has made that observation.
Affirm the session judge order.
You come back.
Let him come back.
So, my lord, that other
Only-
case,
I don't think that there should be will be a judgment on that.
that is not
Raj.
there.
In
37
facts.
will not apply in that other case. In my another case is there that
But the same person.
I'll just come on that.
Same process. Next week, 2 weeks.
No, not
Monday,
Monday, Rashid, yes.
heard Mr. S. Pandit, counsel for the petitioner. Also heard Mr. K. Khan and PP for the state respondent. After hearing the matter at length, the learned counsel for the petitioner has made a prayer for this matter to be adjourned for the day to allow him to produce relevant authorities in support of the case of the petitioner. Accordingly, as prayed for. Mandi Gabyang name? Tuesday.
Lordship.
This is matter on 5th.
Item number 3.
Good morning.
Yes, sir.
Lordship, I'll start.
Yes, yes, please.
So if you remember, on the last occasion when the colleague had submitted regards to the objection, 2 preliminary objections were raised. I'll address those initially. First was, of course, that the application has been signed by the accused and not by the petitioner.
Oh, that,
sorry,
I think he has abandoned that.
All right. Fine. I'll move on to the merits of
What was stressed is mostly on 43D.
Absolutely. So I believe
43D1.
That argument, my lord, it
Besides
was
that-
there in the objections that we have filed.
when
my lord.
asked, he did not stress upon it much, I remember.
My lord,
But you have also conceded that, you see, as far as that aspect is concerned,
because the judgment we
it
have
would,
relied.
it would be relevant only in cases that 482.
My lord, that judgment which we have relied, that is pertaining to 482 applications. However, our contention is that the similar stand should also be taken in cases where bail application has been filed. Because when somebody is filing a bail application, he or she should have knowledge about the incident, about the person, whether he or she is involved or not in the particular case, because he is swearing the affidavit. Therefore, our contention is that, my lord, it should be the application should have been filed by the accused person himself. That is one of the contentions which we have raised.
But is that a condition precedent?
Absolutely not. That is what I've
That is
ever.
our argument, my lord. My lord may.
No, but what you see, I mean, logically, you have a point there. You have a point because you see, Mr. Yaraf, take for example an accused. He is there in custody, judicial custody, or he is in the prison. He doesn't know what is going on. He was brought, he'll be brought to court on remand. In the meantime, no communication is there. There may be communication also with, relatives and so on and so forth. But there must be some proof, particularly that he has been, the issue of application for bail is discussed, and he would say, yes, go ahead or don't do it. Some will say no, don't do it. Some will say yes. That would be communicated to relatives, friends, whatever, or attorney, whatever. So that you see, that aspect of the matter, has to be there on record.
Yes.
And more often than not, his signature on the Vakalama would be sufficient.
Yes.
Then in that case, you see, an application can be filed.
Because applicant
He has
gives.
signed, because that is the provision is also there.
My lord.
See, the jail authority would facilitate that.
Yes. Yes.
But in your case, yes, you may say you are the wife, no doubt. You may say that you have his tacit consent, but that is not enough. That is not enough.
Because applicants give statement, the accused is not involved. So unless he or she has a personal knowledge about the incidents, so it is always.
I don't know. What is?
If I may rebut. Lordship, if you remember, last occasion he did not stress on this very strenuously. I believe the words which were spoken were, it would have been better if the application was filed by the wife. However, candidly, he did not admit that there is no bar statutory preventing the wife from preferring a bail application. Now, in that context, I've made specific reply to this particular point in paragraphs 3 to 7 of my rejoinder. Three to 7 of my rejoinder, which will be at page number 2, Your Lordship.
It's 2.
Page 2. So, in between these paragraphs 3 to 7, if I read out, it will probably be a little cumbersome. But basically, what I've stated there, in Your Lordship, is that the High Court of Meghalaya was established in the year 2013. So were the rules. Now, from that year till date, all applications preferred by.
What are they? You did not, point out any specific rules.
Absolutely. No, I've specifically mentioned there, in Your Lordship, that the rules do not.
Which rule?
No, the rules of the High Court of Meghalaya 2013.
Rule 1, 2, 3, chapter.
No, that is what. That is exactly the point. None of these rules specifically contain any provision, any rule stating that the application must be signed by the accused.
What are the rules?
So the rules number in 78.
What are the rules relating to bail application?
Absolutely. The rules basically say that the application, there's actually no rule stating the application.
Then why are you referring to the rules?
Okay.
If there's nothing there,
Absolutely.
why are you
Hence,
referring?
that is the point exactly.
You're relying on the rules where there is nothing.
I am basically, absolutely, the mention.
Had there been something,
Huh.
and the rules, certain things are missing, or certain things are present,
Right.
then you can rely on that to see that this is correct, this is not correct. But then you just
Perhaps things have not come out the way I've wanted the things to come out. What I've meant to say, what I've meant to stress is,
that there is no
there's
specific
no
rule.
statute or basically no rule which prevents the wife from preferring a bail application. And nowhere is it stated the application of a bail must be preferred by the accused himself.
But you
Now
cannot-
the citations
you see,
which
but
they have relied on.
You cannot refer to the High
Alright.
Court rules when it's not warranted.
Right. Sir, then again, I will assert on the point that on the last occasion when you raised this objection, although it's changed the language.
Generally, you see, now you convince this court again, as I've said earlier, convince this court that elsewhere, or the principle of the law of bail would exhibit the fact that it is not necessary for the accused person himself to append his signature, to give his consent.
Right.
somebody can do it on his behalf.
Right.
Where is, if there are even some authorities on that also, that would be
So
helpful.
authorities in that context only, that is what I'm trying to assert again, Your Lordship, if just take a second, that there is no rule or statute, again, to the contrary either, which says that it must be done by the accused, it must be annexed or attested by the accused, the application. There's nothing to the contrary either. There's no observation contrary either.
So you're throwing the option to the court then?
Absolutely
The court
not.
can go either here or there.
No, Your Lordship. I am basically saying that he has stated that it must be signed by the accused. I am stating that there is no condition precedent for that. No rules state that it should be signed by the accused. In the absence of any rules or any statute stating that it must be preferred only by the accused and not by the wife, it has to be held that it is maintainable.
But again, Mr.
And the citations,
as
Your
I've
Lordship.
said earlier, you see, you have to understand the logic of it.
I understand. But then, Sir, Lordship, if that is to be done, it must be done in all the bail applications. If this rule is to apply, the direction must be given to apply it henceforth and not at the
Maybe.
Absolutely.
Maybe it's a pertinent point has been raised. That would be taken into account. Perhaps it has skipped, this court or any court for that matter, all along. Maybe that would be taken care of. But since this point has been, highlighted here now, so you satisfy that, so that it will be, a benchmark for posterity.
Understood, Your Lordship.
So just satisfy me on that. Otherwise,
Satisfaction, Your Lordship. That is what satisfaction.
it's
I
a
would have to
very-
satisfy if
it's
they
a
had
very,
actually.
very pertinent point. Just
Right.
think about it. We are not going on the merits of your case. That's a
We have
different
not
affair.
entered the merits as
We
yet.
have not entered it. So,
Lordship, again,
because you keep referring to rules.
no,
High Court,
the rules
High Court
and any
rules.
statute altogether which basically prevents the wife from preferring an application on behalf of the husband. The citations which have relied on, Your Lordship, pertain to quashing of an FIR.
Till date,
Lordship.
in my experience,
Lordship.
or even anybody, see Mr. Sinkon also for that matter, he may have filed an application for bail for his clients, many of his
in the
clients,
yesteryears,
at some point
yes.
of time or the other. So maybe it was the petitioner was just the father, brother, mother, whatever, while the accused himself is in custody. So how do we reconcile that? Because that you see, that knowledge part is important. I mean, according to me.
There is a mention in the petition which says the application is being filed on behalf of the accused.
True, but was it made known to him?
And absolutely it was known to him, Lordship. In the
How-
affidavit as well, when we have,
How do you prove that?
Lordship, in the affidavit portion, when we said the facts and the other primary objection which is raised as to why the applicant should be the accused is that the affidavit which would be sworn. Now the petitioner wouldn't be in knowledge of all those facts which were raised, but in the affidavit which has been annexed onto the bail application, it specifically been stated that all the facts were explained to her, and it's only after understanding the facts did she sign on the bail application. The other citation which they have relied on, Your Lordship, I'll just take you to paragraph 5 of the rejoinder. Then in page 3, that in reply to paragraph 4, it is stated that the petitioner, while preferring a bail application, had specifically mentioned in the petition stating that she had filed a bail application on behalf of her husband. A judgment has been quoted in paragraph 4 by the respondents, T.C. Mathi and another. However, it must be asserted herein again that the said judgment also does not help the case of the petitioner, as it does not deal with bail applications, but with appearance of the accused persons before the trial court. Paragraph 6, Your Lordship. That again in this paragraph 4, in Thabir Sagar versus State of Orissa, which they have relied on, the said para of the said judgment quoted by the respondents basically states that an affidavit must be sworn by someone who has knowledge of the facts. It must be stated herein that the applicant, who was the wife of the accused, is well aware of the facts and circumstances. The legal provisions were understood by the petitioner. It is only after understanding the same did she sign the bail application and the affidavit accompanying the bail application. So that is the ground which they are raising, aren't they? That once a person signs an affidavit, he is supposed to know as to what facts or what circumstances are being put up before the court, what is being averred.
Exactly.
And that is what I've stated as. In this paragraph, I basically stated that the points were made known to her. The arrest is not known to the wife, it is known. The remand is not known to the wife, it is known. After understanding all these factual circumstances and after understanding the legal propositions which were, made to her to understand, that she signed the bail application. So, through this judgment, they're basically trying to say Your Lordship, that an affidavit must only be signed by a person who is well aware of the facts and circumstances. If not the wife, who would Who would know the facts and circumstances of the case, Your Lordship? She knows of the arrest. She knows of the remand. She knows of the allegations. How is she incompetent to file the bail application, Your Lordship, or to swear the affidavit? That is my only condition. So, Your Lordship, even if I take time and endeavor to please your court on the point that she is entitled to sign the bail application, I would perhaps come back with the same points again and stress on the fact that there is no condition precedent barring her from preferring a bail application. I cannot be a guinea pig, of course. If any benefit is due to be given to the accused.
You don't use that word, Mr.
Absolutely. No, right.
In fact,
A precedent. Let me.
you should be, yes, you should be glad there that you have triggered. You see, you have triggered a discussion.
Absolutely.
Or you have something which the court has to undertake. Not the court, but the bar and the court has to undertake as far as this aspect is concerned.
Gotcha.
So that is why I see, as far as the parties are concerned,
Gotcha.
it is incumbent upon the parties to convince the court. Unless and until the court is convinced, it cannot do justice. And you know very well, in court proceedings, sympathy, empathy will not come in the picture.
Absolutely, and there are no sympathetic grounds being raised, at least with regards to this
You
point.
don't say, oh, because we sympathize with with the accused, his wife may have signed an application, and okay, that's it. But like again, I say, there must be some legal basis.
It's a technical argument which I'm raising as well.
The presumption would go, you see, that you have to be, you have to empower somebody. You have to, instruct somebody to do things on your behalf. That is the premise on which we proceed. Let us assume that you are the wife and you know everything. In fact, that is also accepted. That is also accepted. But how can that be, taken on board rather, in the legal sense, where even as far as the affidavit is concerned, when it talks about knowledge, when it talks about information, there are two different things. But then,
Lordship, the other thing, when this ground is raised, I believe, Lordship, again, I agree, I absolutely agree. Now, when this ground is raised by them, it is also incumbent upon them to satisfy the court on this point that yes, it is a condition precedent to the filing of the application. Now, they have failed to satisfy on that point, and that is my rebuttal to that point altogether. They failed to satisfy on that point. They have not brought forth any rules or statutes which say that no, it must be signed by the accused and not by anyone else. In the absence of that, it must be maintainable. That is my only rebuttal to this. The onus is on them. They have raised this point. Now they must satisfy the court that no, it is a condition precedent.
Let us look at the provision as far as application of bail is concerned.
Yes.
What is the provision?
483 of the BNSS?
BNSS.
483 will be applicable to this, Your Lordship. This particular case, I mean. Let us see if there's any contrary view. A High Court or Court of Session may direct that any condition imposed by... Okay. No.
Yes, Mrs. Nikon. See, he has thrown the ball to your court.
My lord.
Now you tell me,
Yes.
where is the provision which specifically says as far as who is to apply for bail?
My lord, in the old act, in the old CRPC, my lord, if we see 437.
439, but it would. The corresponding section be 439.
437 is
439, my lord,
the
it just provides the power.
437 is the basis.
Yes.
439 is
Yes.
enabling power of
Right,
on High Court.
Now, if my lord will see 437, my lord, it says, when any person accused of or suspected of commission of any non-bailable offence is arrested or detained without warrant by any officer in charge of a police station or appears or is brought before a court other than the High Court or the Court of Session, he may be released on bail, but such person shall not be so released if there appears reasonable ground for belief. My lord may kindly come to 439. 430. My lord, appropriate sections will be 438.
Anticipatory bail.
438, my lord. It says directions for grant of bail to person apprehending arrest. When any person has reason to believe that he may be arrested on an accusation or having committed a non-bailable offence, he may apply to the High Court or the Court of Sessions for a direction under this section that in the event of such arrest he shall be released on bail, and that the court may, after taking into consideration inter the following facts. Now here it specifically mentions that he may apply. Now, as far as the other sections,
Why he may apply? Because he is out, not already
Right.
arrested. So therefore, he has the freedom. You see, to
So there's one more reasoning for that. Why in anticipatory bail he should apply is because the court is satisfied that this person is anticipating, is not already arrested. That's another.
but we are talking about a person who's already inside.
here, as far as other sections are concerned, my lord, as we have read already at section 437,
Yes.
it says when any person accused of or suspected of commissions of any non-bailable offence is arrested or detained without warrant by an officer in charge of a police station or appear or is brought before the court other than the High Court or the Court of Session, he may be released on bail, but such person shall not be released
See, Mr.
if there.
Mr.
But it
Mukam,
does not
he,
so.
He may be released on bail.
Yes,
See,
but
it does not say.
who has to apply for that? Who has to file the applications, my lord? But as far as 438 is concerned, my lord, it says that it has to be by the accused person.
That we have distinguished that.
My lord, here, as far as other provisions are concerned, it does not say who has to apply for the bail, my lord.
Unless you see, like again, Mr. Yera, of course, he has wrongly referred to the High Court rules. Unless there are some rules or some manual, something which would indicate that when application of bail is made, such and such person should do it. Such and such person, other than the accused, can do it. If there are some guidelines at least.
As far as
Like I said, if there are some precedent, even any authority by Supreme Court or other High Court dealing with this matter,
issue, my lord.
because otherwise,
As far as other sections 437, 439 are concerned, my lord, it shows only the power of the court to grant bail, but it does not provide the procedure who has to apply for the bail, my lord. So
we are stuck
our
on
contention will be my lord, that it has to be by the accused persons, because it is the accused person who is in full knowledge about the incident, my lord, about his involvement. So here, when whoever files the applications, my lord, gives an averment as regard to the fact that the accused person is not involved in the case. So at least some knowledge, personal knowledge, has to be there, whoever is filing the applications.
This submission, sorry, is basically clear. Only this submission which is being made, that it must be signed by the accused. Again, it must be backed by some precedent or some provision. That is not. That is missing.
again, see, it's vice versa. He will say that, you will say that, but where is the conclusion?
In the absence of any
Because you see, this court would like to, at least render some finding on this point. Don't say that it's academic, because it's quoted
yes, relevant as well.
it's relevant because it affects your case personally, it will affect other cases also.
All these
Or
citations
you
which
can
are
you see you can draw again you can draw parallel from the law of evidence of affidavits.
and they have referred to the law of affidavits, Your Lordship, in the paragraph 4 of the
Yes,
result.
yes, you have said that. As far as imputation of knowledge and
Yes.
of facts and law is concerned, whatever.
Yes, Your Lordship. They have averred to that as well. But again, it remains. I mean, we come back to the point that whether she is bereft. I mean, whether she is in knowledge of the facts and circumstances of the case, and she is. The arrest and the remand and the subsequent proceedings are known to her. Not barred from filing an affidavit.
As far as that, you see, as far as knowledge is concerned, I would say that yes, she would be, because you see, once the memo of arrest or other materials, is made known to the accused, then naturally, you see, his next friend or his relatives, it's there. You see, even in the, you see, as indicated by D.K. Basu's case, that is also accepted. That they also have to know. Relatives have to know for for what reason he was arrested.
Right. There's been a reiteration again of that fact to February 2025.
That revelation of fact is, would be taken on record or accepted. But how do we overcome this
Hurdle.
Because
Again,
Mr. Sincon,
a point raised.
you have not also been able to convince this court that your stand is correct.
Because a point raised by a party, Your Lordship, should be proved by it as well. So they're raising it. I'm just simply putting up that there is nothing precedent which says, I mean, there is no condition precedent which prevents the wife from preferring a bail application. Please take us to such judgment, no precedent, wherein they fail.
Again, I have said again, see, you question yourself. Whenever you apply for your client who is accused, and the wife comes or the brother comes, you would do that. The petitioner would be the wife, brother, or somebody else. So it will never occur to you that, oh, the accused himself has to sign.
Yes, this my lord has been raised for the first time, even in my.
It has been raised for the first time.
Citations also are not supporting that fact, ones which they are relying on.
I see. This court may discard their reliance on these authorities. The court will discard that. But again, see, something has to be there. Something has to. You have to give a handle to the court to establish the fact that yes, your stand is correct. Court's stand is correct.
You're stuck.
Can you do a bit of research on that?
My lord, will
Do and see if you come up with something. If not, then the court will make a decision.
my lord.
Right. With regards to the other aspects, should I continue again?
That would
Let
be
the first
material.
hurdle be over.
We'll have to cross this hurdle first.
We should have decided on this first. I mean, before both of us, we went into the merits before. Actually, sorry.
So, when do we have it?
Monday, Your Lordship.
Not Monday. Apa kayo? 2 tarik no? Yeah. We'll have it on 6th.
6, my lord. No, it's 6.
6th.
Lordship.
Heard Mr. Shadaf, learned counsel for the petitioner. Also heard Mr. Sincon, learned GA. appearing for the state respondent. In course of hearing, the counsels for the parties have submitted that some time may be allowed for the parties to seek relevant authorities particularly on the issue of the bona fide of the petitioner who has preferred this instant application. As opposed to the accused person himself, who may or may not be required to prefer the application himself. Accordingly, on primate, this matter is posted for further hearing on 6.
Thank you, Obliged. Good day, Your Lord.
From daily list, item number 1.
Well, 1 and 2 are connected matters. This is with regard to Metropolitan.
Yes.
Number 2, I have a small prayer matter. I have not implicated them as a party matter. So Lordship permits me to file a miss case for implicating them as a respondent. Right, number 2.
Both the matters, my lord, have been tagged. The other matter filed by.
Not necessarily tagged.
It has come before your lordship. Item 2 and 3, my lord. I stand corrected. So 2 and 3. Item 2 and 3. Sorry.
So as far as item 2 is concerned, then
Because
Permission to file this case. Implicating this just
I have to file you.
oh, sorry, 1 and 2. I'm sorry.
Item number 2. Dr. N. Musiga, Larat, Senior Counsel, appearing for the petitioner, has submitted that he may be allowed, that the petitioner may be allowed to file a miscellaneous application to implead
so the Krishna Bodu.
Srimati Krishna Bora
Bodu.
Bora or Bora?
Barua.
Bora.
BARHOOH.
B-O or A?
BOROOAH.
Bora.
Barua.
Bora. Yes. Unuta as a party respondent in this case. Accordingly, as prayed for, the same is allowed. Let steps be taken, then the next date fix. This is the matter after 1 week.
2 weeks.
On the last day, they should have make this prayer.
1 week.
Within a week, Lordship.
1 week.
1 week is good enough. 1 week. Okay.
Number 1 is
Connected to number 2 because issue is identical. What is the issue, my lord? In number 2,
I think number we have substantially,
no, because my lord, what the issue is, my lord, in number 1, we are challenging the order of the special judicial officer granting compensation in respect of land, the land for which notification has been issued, my lord. In the number 2, The prayer is that the entire acquisition proceeding has lapsed. So if it has lapsed, my lord, then in that, if your lordship accepts that after hearing parties and after hearing, if your lordship accepts that it has lapsed, then I will have right to recover the money from the petitioner. That is, or if your lordship holds that no, it has not lapsed, then your lordship will hear my matter whether the enhancement is correct or not. So both matters, my lord, are connected and intertwined.
But number 2 has to be decided first.
Because number 2 is, if it has lapsed, my lord, my friend will not get the higher compensation. If it has not lapsed, my friend may get the high, may or may not get, depending on my argument, your lordship's acceptance of my argument. So that is why these two matters have been placed before your lordship.
But his stand is different. Not different in the sense that his stand is separate as far as the the petitioners are concerned in two, because you are occupiers.
They are in possession.
And he is also said to be an occupier.
He is saying that he is a leaseholder of the land.
Leaseholder, whatever it is.
Yes, my lord.
Admitted landowner by the government.
Yes.
No, admitted.
By way
That
of
is
affidavit.
that I will.
By way of affidavit.
That we will say, because
No,
that is the
okay.
issue which lordship has to
Maybe-
gone into.
that-
Lordship has to decide.
Maybe that has to be
Yes,
decided, but
yes.
prima facie, it appears that since the award was given to him,
The award is also in favor of the persons who are in possession also, my lord.
if they are to recover it, it has to be.
No, that is one
from
part
him.
of it.
So that's a
There-
different thing.
There are
That's
two
different thing.
awards, my lord. One award, money has been received by the petitioner.
Yes.
In the and in the enhancement also some money has been given to them.
Okay.
That is, if your lordship will see, I will place.
You have filed for enhancement.
Lordship. Lordship, after receipt of the award, we have been moving several times before the officers, issued several letters for enhancement for reference, Lordship. Now it has come to light that the award does not include the cost of the land. Now their contention is, if the proceedings has lapsed, Lordship, they have issued a notice under section 37 to receive the award. At the time of the receipt of the award, we simply inquired whether it's under the proceedings or not. Like proceedings has not lapsed, you simply receive the award. We are not satisfied with the award. Then they say, you received the award under objection, we won't say anything. Later you file,
Yes.
yeah, then we can look after it. So now they are stating
No,
that,
after receiving the award under protest,
yes,
you had filed,
yes, multiple letters, several sittings,
section 18 petition and all these things.
everything,
So-
reference, enhancement of the award, everything,
So,
not one.
so the special judicial officer
Then we
has decided the matter.
then we approach before this.
So enhancement was allowed.
Allowed, Lordship.
Against
And
that
that,
state has come.
see, again, now as far as that enhancement is concerned,
Lordship.
it was your application, so
Lordship.
you have received it.
Lordship.
They have also received it,
No.
No,
But you said-
that's the main flaw, Lordship. What happened at the time?
but you are nowhere in the picture then.
Actually, but that has come.
If your lordship
into-
will see the award,
that
their
has come-
names are
no,
there.
no,
Our
Exactly.
names are there in the
Their
award.
names
I
are-
agree.
the
That
award
has
is
come
there.
into light.
But
That has
what
been
you-
concealed,
but
Lordship.
where-
That has been concealed at the time, after the time also.
No,
That
I-
award does not
That-
include the cost
that
of the
will
land.
come to that.
And in the
Whoever
judgment
will
also
concede-
of this honorable
Again,
court, division bench judgment also, it has been stated that the award included the cost of the land in the division bench judgment.
No, we are not. We are not on that.
Lordship.
We are. See, what I would like to understand is this: that are you the primary awardee, or they are also entitled to part of the award or to the award that was given to you, or whether a separate award has to be given to them apart from what has been
One
given
award
to
is
you.
one.
So that is
Yeah,
the question.
basically, Lordship, we are entitled for the value of the land
Yes.
and the occupants for the houses. And some of the houses, some of the major houses are in our name also, Lordship. Still, we are not wishing to take the value of that land also. And his submission, Learned Age's submission in this regard, that other council's submission is that we received the award after the period has lapsed.
That is on merit.
Fine. If it is so, Lordship, then why they had issued that particular letter under section 37 to receive the award?
My lord, the state has not, in my case, the state has not filed affidavit. I've been pleading them, let them file affidavit, my lord. The matter be heard. If I succeed, I succeed, my lord. If I succeed,
If you succeed, then the
everything goes
entire
well.
acquisition proceeding will go.
Then
And
it's
entire
still-
acquisition
If
proceeding
it
will
goes
go.
also, then
Then in that case also, then
New
why will
acquisition proceedings should
I
be
will not,
initiated.
why, no, I will not initiate.
And if we are not,
That is up to
if
the
we are,
state.
if we are not entitled to that amount which we had received, in that new acquisition proceeding, that amount
We should be happy that land
definitely
acquisition lapses, my lord.
And we go for acquisition.
no, and the amount which we had received, Lordship, that is on
He
record.
is only after money, my lord. That's the whole problem.
That will be adjustable, isn't
Yeah,
it?
definitely. That's what
If
if
we decide to proceed, I mean, because now we have got new Shillong township also, my lord. Entire secretariat is
Whether
getting
they-
shifted, my
Lordship,
lord.
whether they-
Whether there is a need to pay 30 or 40 crore rupees at this point of time for acquiring a land where there are persons who are already occupying, and I don't have possession of the land, my lord. So that's a public interest vis-a-vis private interest, my lord. What if we need this piece of land as on today in the change scenario, because the initial land acquisition notification was 2001. Now 24 years have gone, my lord. In 24 years we have paid some money, enhancement has come.
The question,
Moreover, my
see,
lord,
at this point of
moreover,
time,
my lord, what is
at this point
important-
of time, see, the question of needing the land or not needing the land will not come.
Yes, and
You have already acquired the land.
and recently they
Acquired and
recently
I
they
did
have-
not take possession. And their case is, since I have not taken the possession, the acquisition proceeding has lapsed. That is their case, my lord. So I have to take a stand whether it has elapsed or not. That is also
Lordship,
in
possession
which
comes
we have
as
to
per
file
section
counter.
38, as per section 38
Now
of the
it's
Act,
no
possession
longer-
comes after full payment of compensation.
Exactly.
It's not, they said you kindly hand over the land. We are not selling the land. When a person sells the land, then he used to hand over the land. When in an acquisition, nobody has hand over the land. Governments
Well,
take
he
over
should
the
be
land.
happy that the land acquisition, he should support my case. my
And
lord,
Lordship,
that it is
in this
that.
regard, no, and Lordship, in this
But he
regard,
wants
the
money,
amount
my
which
lord,
we had
that's the
received,
problem.
Lordship, they have given an notice under section 37.
He should
Under
have
that,
the
we
land
received that award.
is
Now,
left.
if they said that land is not because we have wrongly, who delayed it, Lordship? They, as their version, they said that the proceedings have lapsed. Then who delayed making the payment? It's their fault in making the payment after, if the period has lapsed. It's their fault in delaying the award. It's the if it is their fault, then why we are entitled to refund it, Lordship?
Okay, all those questions we look into.
Yeah, we are not entitled to refund it.
And that's why I'm not
And since-
joining my
and
friend,
since
my lord.
proceedings has not, whether it's lapsed or not,
Anyway,
whether,
that will
That
be,
has to be
if they-
decided. That has to be decided by this honorable court.
but then since now,
So then we have to
has come
file.
up-
State has to file reply, because the state is a party in this case, and
In
my
case,
friend
my
has.
lord, the state is already a respondent, my lord. I am pleading him as a respondent also. So once they file affidavit, the matter will be heard. So the first item number 2 has to be heard, my lord. If that is decided in my favor, then yes, number 1 will become
and
interest.
they need a children park. They will build a children park on that land also.
Children
That's why.
There is no
That is
children.
true. That was
We got a
I'm
copy.
not-
We
FPSC office.
no, we got a copy of it also.
question of bona fide requirement will be looked into.
The original purpose for which the land is required, that has been no more. Now we got a copy
He
of
should be
that
happy
letter.
when the land acquisition lapses. He remains the owner of the land.
And he will get more money.
I'm surprised by the submission made by the AG that we have to refund it. Lordship,
That
we have
that
received under
question
section
will,
th- that we received
that
under
question will
section
be
37.
examined by your lordship. That
That we
with
received
the-
under section 37. If lapsed, then why you have awarded the amount?
Mr. Barua, don't worry. What he is saying is correct. You sell the land at a very high price and then refund the money to them. You'll get your profit.
That's the end of the litigation. That's a,
He said it privately also. You don't know.
That's a joke. So when do we have this?
after 2 weeks.
Within a week. No, Lordship.
Because the miscellaneous application replied said first.
He'll file. Oh, within a week. Yes.
Within a week, Lordship.
He'll file and then you can reply and then we'll see. Look at number 1. This is matter up to 1 week.
Wait for me.
Item number 3.
You have started, Mr. Shi?
I have started lordship with piecemeal lordship. That is why matter was fixed Friday, hoping that there will be no division bench on Friday lordship. Because this matter it will take little time lordship. Because earlier also the matter was heard. Matter was argued by learned senior advocate Mr. Mojika. So
What do we do?
I am ready, my lordship, because last time I have come till that inquiry report, lordship. That is at page 25. And today also,
We
yes, Lordship.
we have. Of course, I can say practically another 15 minutes.
That's why, Lordship, because that is the problem, Lord. Then, my Lord, any day, Lordship. any day.
We'll have it. No. That's all. Yeah, we'll have it on 14th. 14, okay? On pre-made by the parties. This matter for hearing on 14th. 14, Mr. Shulai, you are there.
I'm there, Your Lordship, in some item. Not on 14, Your Lordship. On 14, we have. Lordship, if it can be taken up on 21st.
Yes,
or 19, Your Lordship. 19 or 21st.
19.
19, Lordship.
19 or 21st, Lordship.
We'll take it on. See, this is a very old case. I don't want to delay this matter.
19 or 21st, Lordship, because on the 14 also we have matter with sir before other.
Okay, 19.
19, Your Lordship.
I know 19.
19.
19.
Apply, Your Lordship.